so the next case we have coming up is set for 11 o'clock, and it's State of Ohio, ex-rel Hilton versus City of Lorain. I figured all the attorneys were here with us. It's still just a little bit, maybe a minute or two.
Sure.
Are you expecting anybody else?
I don't believe we are.
Oh, yeah.
All right, then why don't we go ahead and proceed? Each side will have 15 minutes. You may, as the appellant, you may reserve up to 5, just let me know. And I know this is really not relevant here, but we like to say it for purposes of the record, and that is that, you know, that you can't use names of victims or of children. I guess all you need to do is stay behind the podium, keep your voice up, and then let me know how much time you want to reserve.
Thank you, Your Honors.
Thank you. And we've read the briefs, we're ready to proceed.
Great. May it please the court, I'd like to reserve 3 minutes for rebuttal, please.
Sounds good, thank you.
My name is Ken Smith. I'm one of the attorneys for the appellants in this matter. I'm here with my co-counsel, Anthony Coyne, Gerald Phillips, and Adam Youth. We are asking this court, as appellants, to reverse the decision of the Lorain County Court of Common Pleas in denying plaintiff's motion for class certification, and alternatively for this court to reverse the trial court's denial of appellant's motion for relief from judgment and reconsideration. Ultimately, we believe this appeal is about common sense. The allegations in the First Amendment complaint and in plaintiff's motion for class certification are clear, that the appellees overcharged each and every one of its customers for water and wastewater utility services. These customers, or ratepayers, are easily identified and defined. They are the persons or entities charged for water and wastewater utility services. Appellees can identify and define these people. They regularly bill them. And they are the same people that have all signed the same agreement with the City of Lorain for water and wastewater services that has been in effect for years. While the trial court did hold that appellants satisfied 5 of the 7 requirements under Civil Rule 23 to maintain a class action, it held that the proposed class was not identifiable and unambiguous, and further that appellants failed to show the Civil Rule 23B requirement was met that a class action be a superior alternative to individual litigation. The trial court's decision reflects a failure to conduct a rigorous analysis required under Civil Rule 23 and its obligations to even amend the class definition if needed, as per the Randleman case, and it constitutes an abuse of discretion that may deprive approximately 28,000 customers $16 million in estimated overcharge fees. This is especially true where the law is clear. Any doubt on the propriety of a proposed class, if any, should be resolved in favor of allowance of the class action, as held by the Esplin case and many others. Now, in its ruling denying class certification, the court first held that the proposed class was not easily identifiable and that it was not unambiguous as required under Civil Rule 23A. Plaintiff's proposed class definition, all ratepayers who were charged water and sanitary sewer rates, fees, and charges by the City of Lorain since May 7th of 2012, makes it readily apparent who should be part of the class. And to be clear, it does not matter if it's an individual, a business, a government entity, etc. Their damages all flow from the same conduct, the same faulty formula utilized by the City of Lorain to overcharge its customers. And the bills issued by the City of Lorain to its ratepayers are the same. There's no individualized formula or method for charging individual ratepayers. They all sign the same agreement, the owner's information sheet, which, according to Lorain's own ordinances, constitutes a contract once accepted by the utility. Moreover, the trial court's hang-up on how to identify class members is simply unreasonable. Once again, the City of Lorain knows who its customers are. How else could it bill them? There are a number of ways to identify these ratepayers as well. Appellee's own billing records, which have names, addresses, account numbers, Lorain Utilities' own annual reports, and even real estate records, as Lorain's ordinances outline who customers are of the utility, owners of property. Contrary to the trial court's concerns, these records are more than likely than not to exist, even going back to 2012. Certainly the real estate records exist going back to 2012. And indeed, given the foregoing, it is telling that the appellees in their briefing stopped short of saying that these records don't actually exist. Instead, appellees feign ignorance and say that we appellants are speculating as to whether or not these records exist. They do. The identifiability and unambiguity of the class is common sense, and the trial court's ruling unreasonable. And finally, while appellees raise great issue over the use of the term ratepayers in the motion for certification, this is an argument over mere semantics. And to the extent the trial court was confused or concerned by appellants' use of customers in their amended complaint versus ratepayers in the motion for certification, the court could have, in its duty to conduct its rigorous analysis, held a hearing on the issue, had appellants amend their complaint, or even sua sponte amended the class as their power under Civil Rule 23C. The court did none of these things. And in a case that had been pending for almost 5 years before this decision, where the court had not adopted a case management schedule in this approximate 5 years, the court chose instead to eschew its duty to conduct the rigorous analysis, and instead of clarifying any unjustifiable confusion, it took the path of simply denying class certification.
Well, it seems like part of the reason was the trial court was saying that the plaintiffs had not met their burden, so therefore there was not really anything to really rigorously review, in other words.
Well, again, Your Honor, we think there was plenty of evidence in the record to show that the plaintiffs did meet their burden. It was either attached to the reply in support of the motion for class certification, which is permitted under the rule. It was attached ultimately in a motion for reconsideration and relief from judgment. And beyond that, as we've outlined here, this is one of the elements that candidly appear to be self-evident, that we could identify the class. So to counter that, we certainly think there was enough evidence, and plaintiffs certainly did meet their burden of proof here. Now, as it relates to appellant's third and fourth assignments of error, the trial court also abused its discretion in failing to find Civil Rule 23B3's predominance and superiority requirements were met. Beginning with predominance, to meet that requirement, appellants had to demonstrate that the issues subject to generalized proof and applicable to the class as a whole predominate over those issues that are subject to only individualized proof. Here, there can be no doubt that generalized proof predominates over this entire class. First and foremost, yet again, each class member must enter into an identical agreement with the City of Lorain, the owner's information sheet. And as this very same panel has held in the context of a class certification appeal, in supplemental authority cited by appellees, Williams v. Kissling, Nesco, and Reddick, courts generally, and I quote, courts generally find that a wide variety of claims may be established by common proof in cases involving similar form documents or the use of standardized procedures and practices. The form documents here, they're the agreements between the class members and the City of Lorain and the bills. Now, upon entry of these agreements, all customers are subject to standardized procedures and practices as outlined in the revised code and in Lorain's own ordinances. This alone should satisfy the predominance requirement. However, each and every class member was also subject to the same overcharging from the City of Lorain. That formula is the same. It is not individualized to each and every class member. Indeed, when you enter into an agreement with your public utility provider, you don't get to negotiate your own rate. You are subject to what the public utility charges. Further, the trial court's assumption that every class member would have some individualized formula needed to quantify damages is just frankly incorrect. While class members may have different damages depending on how much they ultimately were overcharged in comparison to their actual water consumption, for example, class members have different measures of damages in almost all class action cases. Civil Rule 23 class actions being an illusory mechanism if varying damages among class members was fatal to certification. Further, at the class certification stage, appellants did not need to show the exact formula for Lorain's overcharging, just that it was more likely than not that such a formula exists. And in finding such a formula does not exist, the trial court improperly did not accept the allegations in the amended complaint as true, or accept the accuracy of the attachments to the pleadings to the motion for class certification, as the Mazingo case states it must. The trial court also took issue with the potential need for subclasses if different class members have different damages or are ultimately found to have been charged differently in discovery. But to the extent there ultimately would need to be subclasses, they would be easily identifiable in discovery, and again, their damages would not be based on individual determinations, but damages common to the subclass as a whole. And again, if the court was so concerned about the breadth of the class, it could have sua sponte modified the class on its own accord to narrow it, as outlined in Appellee's own cited Hub versus Beck Energy case, and an appellant's supplemental authority that was recently filed. Appellants in their motion for reconsideration attached the draft report of their expert, Paul Comiskey, to show just how a damages formulation could be ascertained common to the various class members. This was done through an analysis of the public records from the city of Lorain itself. And yet the trial court, again, failed to give credence to appellant's expert report in the motion for reconsideration or relief from judgment. Now, as it relates to the superiority requirement, it's simply obvious that a class action is the superior mechanism to resolve these common issues among the approximate 28,000 ratepayers in this class. Otherwise, the appellees would be potentially flooded with tens of thousands of lawsuits, all based on the same agreements, the same formulaic billing records from each taxpayer, and be potentially inundated with 28,000 Paul Comiskey reports. Now, that's to say nothing as to whether or not this is even feasible, as Mr. Comiskey ultimately finds that the average overcharge would be about $628 per class member. Clearly, a class action would be the superior way to handle this case. Now, the trial court here was clearly confused about issues that appellants believe were readily apparent as non-concerns. And in accordance with its duty to determine whether an action should be maintained on a class basis, the trial court should have held a hearing, and its failure to do so in these circumstances constitutes an abuse of discretion. Now, as cited by the Ohio Supreme Court in Warner versus Waste Management, the equivalent federal standard is that where the pleadings themselves do not conclusively show whether the Rule 23 requirements are met, the parties must be afforded an opportunity to discover and present documentary evidence on the issue. In denying the request for a hearing, the trial court assumed appellants could provide no additional information to rectify the court's perceived deficiencies with the certification motion. Such an assumption was improper and compelled appellants to file its draft report of its expert Paul Comiskey. Now, the Comiskey report, which again outlines the extent of common overcharging of each of the class members, shows that a hearing where appellants could have explained the findings of Mr. Comiskey was necessary for the trial court to fulfill its independent obligation to determine whether the class should have been maintained. For example, a hearing could have illuminated that all residential customers were subject to the same flat fees and rates for water consumption, and that these total charges increased dramatically every year from 2016 to 2020 before tapering off after this lawsuit was filed. The trial court also committed a reversible error where it denied appellant's motion, Civil Rule 60B motion. And Civil Rule 60B permits reconsideration of a decision on the basis of either excusable neglect or for any other reason justifying relief in part. Now, here, as discussed seconds ago, appellants outlined in their motion for reconsideration that a failure to provide a hearing deprived the trial court of hearing additional evidence, such as the findings of Mr. Comiskey. Yet the trial court did not even discuss Mr. Comiskey's report in its order denying the 60B motion, instead finding that appellants could have, and appellant's motion for reconsideration also highlighted the court's ongoing obligation, whether at the certification stage or after, to alter or amend the certification order as circumstances change and litigation strategies evolve, as outlined in Civil Rule 24CA012095 and the Randleman versus Fidelity National Title Insurance Company case. Here, the court had an obligation to consider amending its certification order in the face of evidence that directly spoke to the court's qualms with granting class certification. Indeed, the trial court could have sua sponte amended the class, but it's clear that the trial court erred when it failed to do these things. We therefore ask this court reverse the decision of the Lorain County Court of Common Pleas to remand the case for further proceedings.
Thank you. And you have 15 minutes.
Thank you, Your Honor. May it please the court, my name is Michael Nacon and I represent the appellees in this matter. Generally speaking, Your Honors, the court's determination to not certify a proposed class must be examined for abuse of discretion, even an enhanced standard of abuse of discretion, as the Ohio Supreme Court has determined many times that the trial court is in the best position to determine the management of its docket and whether a class action should be maintained. In fact, it is at the trial level that decisions as to class definition and the scope of questions to be treated as class should be made. That's from Mars v. CB Chemical.
But there is a case law that talks about being liberally granted, for the class actions, if it appears
There is, Your Honor, as long as all the standards are met, each of those 7 elements. And in this case, the trial court found that 2 of those factors, one of them being a 2-part factor, had not been satisfied. In this case, the trial court did conduct a rigorous analysis, and while I do believe that the plaintiffs failed to meet their burden in the first place in meeting those factors, the court nonetheless conducted a thorough 28-page decision where it laid out each of the things that it considered and each factor of the test. This was not a mere offhand denial. This was a thorough consideration of the matter, a rigorous analysis, and ultimately the court determined that class action was not appropriate. Key to this, Your Honors, is that a class action proponent must, by a preponderance of the element, prove that preponderance of the evidence, that each of those 7 elements must be met. In this case, they simply failed to meet this burden when they moved for class certification. The only documents attached to their motion for certification were an audit report of the City of Lorain and affidavits of counsel. They simply failed to meet their evidentiary burden, which they were bound to do to maintain a class action. Critically, the issue is not necessarily who was charged for these water and sewer fees, it is who was paid, who has been damaged, as plaintiffs allege in this matter. Now, significantly, approximately 45% of the City of Lorain residents are renters. They are not going to appear on property records. They are not going to appear on billing invoices. Now, whoever paid those charges cannot be determined by any common proof. They're simply not identifiable, as the trial court below found.
Is that in the record? Because that's not always the case, is it? If you rent, sometimes utilities are in your name, unless there's something different in Elyria than there is in other cities.
Sometimes they are, sometimes they are not, and that's part of the plaintiff's burden here, is that they did not produce any example documents even at the trial court level to say whether or not this is truly an issue. But so one way or another, if those bills are in the name of the person who actually owns the property, and again, all property records are going to be, as plaintiffs have suggested, would prove the class identification, then you're not going to know whether there's a renter. And this is 45% in 2022, according to the U.S. Census Bureau. This is going back now to 2012, as plaintiffs have proposed. That's going to be hundreds of thousands of individuals over those years, obviously some repeating, but the expanse of that is unmanageable.
But couldn't that be worked out? I mean, just even through a class that says not including property owners, or any number of ways that you could try to work that out if you couldn't determine, exactly what was paid by whom. You're going to know who paid what. It's just a matter of whether they were the property owner responsible for it or is the renter responsible for it. And that goes into your injury in fact. Is that what you're alleging?
Yes, Your Honor, and frankly, I do not think that there is any way to identify who actually paid these. And it's a
There
reason.
won't be a record of who paid a bill?
Only that it was paid, not who actually paid it.
But you'll have the account name.
You'll have an account name, you'll have property records, maintained through the county, but as far as the water department itself, you'll have an account name, but you won't have who actually paid that invoice, who paid that bill.
If that's the case, then that would apply to anything, couldn't it? I mean, electricity, it could apply to any utility, it could apply to a number of things. You can't assume just because something is in somebody's name that they actually paid the bill. I mean, I pay bills for my kids all the time.
Right. And Your Honor, in a class action, you would be the one who would actually suffer an injury in fact, not your kids. I think that is a significant issue that we face here moving forward on appellant's proposed class definition. Right. And the trial court, equally found, without referring to rental issues, that the class was simply unidentifiable and was ambiguous. Going so far as to define the class as unworkable. Appellants have claimed that the court should have exercised its Civil Rule 23C authority to amend the class action definition at any time. It could have done that had a minor tweak been necessary, but this was not a situation where one thing needed to be corrected. Well, simple thing. The court found it unworkable by any extent, emphasized that. Yeah.
I have to tell you, just, over the years handling some class actions and so forth, this just seems like such a simple thing. I mean, compared to the class actions that I have reviewed for certification, so I'm trying to figure out what makes this so complicated.
Well, I think in part what
That
makes
it's unworkable.
Well, I think it's unworkable in that, as appellants have proposed the class definition, all ratepayers who were charged from May 7, 2012 to the present. And, does that just mean people who actually paid the charges, only people who, were charged and then paid? I think that it's a very broad breadth there that they're seeking, and I think that that poses a significant issue to actually being able to identify common injury and, transferring now to the predominance issue, as this court found in Williams v. KNR very recently in 2022, and then re-emphasizing that decision in 2023. Plaintiffs in a class action must demonstrate that they can prove through common evidence that all class members were in fact injured by the defendant's actions. There is no predominance in this case because there's no common evidence to show who all was actually damaged by the allegations.
Well, that's just the general law. In KNR, we sent it back on the basis of the court not doing a rigorous enough analysis, and quite frankly, it's 87 pages. So that's a very complicated case. So what about having a hearing on this?
Well, Your Honor, simply put, there is no entitlement to a hearing. The Ohio Supreme Court has been very clear on that. They've repeated it over and over again. Appellants argue that a hearing would have afforded them an opportunity to explain any issues. However, the trial court determined that it did not need a hearing because it was clear from the briefing that the class could not be certified as proposed by appellants. I believe that issue is very straightforward on the case law. There is simply no entitlement to a hearing on the motion to certify
So
or
it's
on
just
the
a
motion for
discretionary
reconsideration.
decision. It's a discretionary decision.
Yes, that is within the court's province. Yes. And as far as the final component which the trial court found lacking via superiority, a class action must be superior to alternative proceedings. And in that consideration, under Civil Rule 23b3d, the court must weigh difficulties likely to be encountered in the management of the class action. This court found, in addition to the class being unidentifiable and ambiguous, that it simply would not be appropriately manageable for the court to handle. As I stated at my opening, the trial court is in the best position to manage its docket and to control itself and knows when a class is appropriate. Yeah. As far as the motion for reconsideration and relief from judgments, on the whole, appellants failed to provide the court with any reason to consider that motion. Appellants state that they provided additional documentation that a class action would have been appropriate in the first instance. However, a motion for reconsideration or relief from judgment, just as with motion to certify, is subject to an abuse of discretion standard. In this case, the appellants failed to provide any reason for the court to reverse its judgment, denying class certification in the first place.
Now, my understanding is, though, as I recall, you're alleging that the 60B was inappropriate.
I do believe there's a significant question whether 60B is even appropriate for...
Because it's not a final appealable order.
Because it's not a final appealable order, and 60B only applies to final judgments. Nonetheless, the court conducted a 60B analysis providing the benefit of that doubt to the appellants and found each of those prerequisites lacking, for it to reverse its decision. And really, as the trial court stated in its opinion, another well-reasoned opinion in denying the motion for relief from judgment and reconsideration, there were simply no operative facts on which the court could reverse its decision. The motion was simply asking the court to reverse itself. It provided no new evidence, it did not identify any mistake, excusable neglect, or any other undue justice that would allow the court to go back on its decision. Appellants attempted to introduce a draft expert report, which they had had for years prior to the denial of class certification. The court specifically noted that new evidence does not just mean evidence you're introducing for the first time in that motion. It means newly discovered that you could not have reasonably discovered prior to judgment in the first place. For these reasons, the motion for relief from judgment reconsideration was appropriately denied, and appellants were not entitled to a hearing on that matter. Now, additionally, appellants have now, for the first time on appeal, argued that the court should have exercised its 23C authority to sua sponte amend the class definition and then certify the class. That argument was never waived at any point below or in the motion for reconsideration even. And as such, that is waived and it cannot be made here. In closing, Your Honors, simply put, the definition that appellants have proposed is unworkable. The trial court made the correct decision in denying class certification, and they're entitled to significant deference in an abuse of discretion analysis of upholding that opinion. Thank you.
Thank you. You may proceed.
Thank you, Your Honor. I think the appellee started off with a discussion about the abuse of discretion standard being a high standard, but I would like to point the court to, again, the Mozingo case, citing Hill versus Mindtree, Ohio. A determination by a trial court regarding class certification that is clearly outside the boundaries established by Civil Rule 23, or that suggests that the trial court did not conduct a rigorous analysis of whether or not the prerequisites of Civil Rule 23 are satisfied, will constitute an abuse of discretion. Appellees also took issue with the evidence that was attached to the motion for certification. Appellees, of course, left out that additional evidence was attached in the reply in support of the motion for certification, which is permitted again by the rule, and in their 60B motion. Appellees also raised an issue as to the class identifiability and who paid the charges, in that it apparently doesn't account for renters and class members like that. So Appellee's position ultimately is, because there's a significant population of renters in Lorain, or that gets their water services from the city of Lorain, that it's okay to rip these people off because they can't really be identified as to who paid. This is exactly why the court should have done additional analysis to find out these issues. The court ultimately could have found that a subclass was appropriate. But moreover, Appellee's position, if accepted, means that it would ultimately be immune from class actions in utility cases because there are just so many renters that get their utilities from the city of Lorain.
Counsel, could the court have independently looked at a subclass before certifying any class?
Yes, Your Honor, it has that ability under Civil Rule 23C.
Okay, so it can just change and amend the class?
It can, on its own accord. Appellees also, again, raised issue with the term ratepayers, and who does it mean? Does it mean people that were charged and still didn't pay? Well, even if someone was charged and didn't pay, they still owe that money to the city of Lorain, unless they're making the argument today that they're waiving any of those collections. They could get a credit on their bill, and therefore they've all suffered the same damage as the people, and they would get the same relief as the people who did ultimately get overcharged and pay their bill. And finally, the appellees made issue of the motion for reconsideration. I believe the appellee stated that appellants showed no reason that the trial court's decision should be reversed. But again, appellants leave off the additional evidence that was attached to the 60B motion. And here, there's a reminder that the trial court has an ongoing duty, again, pursuant to Civil Rule 23C, that doesn't exist in a lot of other judgments and a lot of other cases.
Counsel, you need to wrap up.
Sure. Your Honors, Civil Rule 23C mandates that courts continually modify the class if needed and the circumstances change. Again, we are requesting that the decision of the trial court be reversed and remanded for further proceedings. Thank you, Your Honors.
Thank you. Thank you to both sides for presenting the arguments today. The court will take the matter under advisement and issue a written opinion that will be sent to everyone. And we also release electronically our decisions on the Supreme Court website. So thank you all very much, and hope everyone stays warm and dry today.